a Chief Justice, as the 51st Chief Justice of India within a few months. His Lordship is, as you have seen, prefers to maintain a very low profile. But behind that facade is a person who is a hardworking, absolutely dedicated to the justice delivery system, and who had a very vast experience before his Lordship elevation as a judge of the Delhi High Court, as a lawyer, not only in the High Court, Supreme Court, but also in the District Court. In fact, before his Lordship started practicing mostly in Delhi High Court, his Lordship was practicing in the various district courts of the of Delhi, where he attained this advocacy skills and a knowledge of law in various branches, especially in criminal law. Though most of us are familiar as a judge of the Supreme Court that his Lordship has been rendering landmark judgments in constitutional matters, in tax matters, commercial law, but many of us are not aware that his Lordship is also proficient in criminal law. In fact, after his elevation as a judge of the Supreme Court in 2019 and till date, his Lordship has authored about 100 judgments. And about 36%, I'm not very sure but about 36% of the judgments have been in criminal case. In various, and he has been part of the many landmark judgments of recent. Of course, we know of the electoral bonds, which is a dramatic kind of a reassertion of the democratic values of the right to freedom of speech, fundamental right to the right to know about the whole information, the right to information or the guaranteed right is ingrained in the judgment. And a wonderful exposition of that fundamental right we find in the judgment. There are many others which I need not mention. All of you are practicing law, judges were well aware of these many decisions of this Lordship. Apart from the legal acumen, we have seen as a judge of the Delhi High Court as well as of the Apex Court, he has been known to have rendered judgments which infuse the democratic principles, the democratic principle in actual play in our lives, what we find in the judgments of his Lordship. Just to take a few examples, the right to privacy is another landmark where that Aadhaar judgment also we have seen, where the right to privacy, the fundamental right, has been highlighted, which has a far-reaching implication on various aspects of law and governance in India. And also his Lordship was very careful to emphasize on a need for a robust data protection, because we are entering into a new era of digital world, and our Indian judiciary is also in the midst of this revolution taking place, where data protection is also a serious concern, not only in judicial aspect, but in other areas of our social life. His Lordship has we also know about the decriminalization of Section 377, the role played by his Lordship in judgment. It is indeed a watershed moment in the fight of LGBT rights in India. What we see from various judgments of His Lordship is a deep understanding of the constitutional principles and human rights, always in the forefront in all these judicial expositions. In fact, these one can see from the lineage, rich lineage, His Lordship. All of you, as the students of law, are aware of this famous habeas corpus case, where Justice H.R. Khanna, in order to uphold the highest tradition and the independence of judiciary, resigned. And His Lordship H.R. Khanna also had written the dissenting opinion on this case, ADM Jabalpur, we all know. And His Lordship's own father was illustrious judge of the Delhi High Court. And His Lordship's mother also was a teacher in a college. So we see a very rich heritage, a rich belongs to, His Lordship belongs to a very notable, not only legal, but also academic background, rich family background, which Lordship has inherited and which we see in his day-to-day, not only day-to-day deliberations, but also in his judgments. And we had also the privilege, honor to have His Lordship inspecting our central jail just a couple of days back. The concern His Lordship has shown for the under trials, the basic fundamental rights to be represented, to have the best access to justice. These are all doesn't come in a day or become, it's all inculcated values and a deep understanding of the social needs in the light of the constitutional principles, which is contained in a preamble, which guides us, especially the judges and the legal fields. I do not wish to take much of your time, as we have here assembled here to listen primarily to His Lordship. But this is a few words, at least I can speak of His Lordship, of the illustrious career which Lordship has had as a lawyer, as a judge, and the wonderful exposition of law, especially in the field of human rights and our basic and transparency, accountability. In fact, the Lordship also one of the bench which decided that the office of the Chief Justice of India also will not be exempt from the Right to Information Act. These are that judges are also the office of the Supreme Chief Justice, also an office which is accountable to the people. So these are some of these snippets of the principles which has guided His Lordship. One can see in these numerable judgments, and of course, coming to those who are familiar with commercial law, the Vidya Drolya, which is a standard judgment. Anybody who is involved in law of arbitration will invariably would read and refer to Vidya Drolya, where His Lordship has gone in deep extent, various facets of the principles involving arbitration law in India. Well, there are so many things which I wish to speak, but that because of time constraints, and also, as I mentioned, that we are primarily assembled here to hear His Lordship's. I thank you, all of you here, for being present here, and welcome His Lordship, his visit to this Jammu and Kashmir. This is, of course, the second visit. The first visit was in a very formal manner in Nalsa, where there was very little interaction with the judicial system. There was more in the human rights, realm of human rights. But we are happy that His Lordship has taken over as the executive chairperson of Nalsa, and he has much more direct and direct access, and not only access, but the responsibility and for ensuring that the legal aid system, which is in fact very unique system, as Lordship also mentioning that day also, this is a very unique responsibility which has been cast upon the judiciary And there is no other judiciary which has a dual role of not only dispensing justice, deciding cases, but also enable the common litigant, the people, to have easy access to justice. So this kind of dual role which we are playing, perhaps there is no other institution, judicial institution in the world which plays in such a remarkable manner as Indian judiciary has been doing. And one more, we can say that this present movement, the entire legal service movement, is led by his lordship, who has shown his exemplary commitment to the cause of the legal system in this country. Thank you very much. And
Thank you, Lordship. Lordship's eloquent welcome address has set a distinguished tone for this event, highlighting the importance and significance of the program. Lordship's guidance and profound commitment to upholding the tenets of justice serve as an inspiration to all of us. Honorable dignitaries and guests, today's event may be seen as a progressive platform for sharing insights and exchange of thoughts, furthering the synthesis of new ideas through interconnections and mutual learning. In our shared judicial mission and in context, it stands as a testament to the concerted and committed resolve to formulate an engaging, interactive, and collective judicial ecosystem. Today, we feel extremely fortunate to have the inspiring presence of Honorable Mr. Justice Sanjeev Khanna, Judge Supreme Court of India, with us in this unique introspective discussion. Lordship's presence has elevated the significance of this event and has certainly added meaning and dimension to it. Lordship is acclaimed for his exemplary intelligence and an unparalleled dedication to uphold the highest standard of judicial system and rule of law. Lordship has presided over numerous landmark cases, and his Lordship's judgments are acknowledged for steadfast adherence to constitutional principles and for safeguarding the rights and freedom of all individuals. It's my honor and privilege to request Honorable Mr. Justice Sanjeev Khanna, Judge Supreme Court of India and Executive Chairman, National Legal Service Authority, to for Lordship's presidential address.
We can use this one. Fine. That's so that's not to point is also. No, I don't remind the point. I think just put it on the side. So yes. Thank you all. The Chief Justice of Jammu and Kashmir and Ladakh High Court, Mr. Justice N. Koteshwar Singh, thank you for your kind words. Mr. Justice Tashi Rapsan, Mr. Justice Atul Sridharan, Mr. Justice Sanjeev Kumar, judges from the High Court of Jammu, Kashmir and Ladakh, members of the District Court, and I can see sitting behind the new entrants to our district judiciary. Adab, Namaskar, and good evening. I have come here both as a executive chairperson of NALSA, as well as to interact with all of you as judges of Indian judiciary. Kashmir as we know, is often referred to as the heaven or the paradise on earth. Last 2 decades, there was some trouble in the paradise, but I will not rate it as paradise regained. Certainly not. It was always a paradise, continues to be a paradise. I have traveled extensively last time and this time, and I can tell you each location is as picturesque as the other, whether it's the mountains, the snow peaks, the rivers, the meadows, the flora and fauna, that apart, art and culture. It's a complete exposure to all of this that makes it a paradise. As it was said that my initial introduction was in the district courts, and I'll begin by referring to certain data. I've been over the years gone into data because I feel data helps us understand the problem. And also, it's not a critique as such as, please don't take it as a critique. It also helps us in improving and setting us goals and how do we move forward. If you look at this data, the Supreme Court in 2023 handled about 52,660 cases. The High Courts, the figure jumped to about 2 lakh and odd cases. But when it came to the district court, the figure is almost 10 times more. 2 crores 37,000 cases. So one thing is very clear. It's the district court which is the backbone of the Indian judiciary. And that is true even for J&K. This is the first point of engagement which a citizen has with the judiciary. And to a large extent, the success of judiciary or its acceptance as a dispute resolution mechanism in which people have faith and credibility depends upon the district judiciary. I'm not undermining the role of the high courts or the Supreme Court, but the figures speak for themselves. If you look at the pointer number 2, it says misconception that district courts do not deal with fundamental rights. Just like to clarify that. Why do I say so? Most of our statutes are based upon fundamental rights or directive principles of state policy. Statutes, secondly, often address conflict between two rights, prioritizing one over the other. So don't be under the impression that you are not, district judges or district court judiciary is not dealing with the issue of fundamental rights. You are in one way or the other dealing with, when you interpret the statute, you take into account the constitutional morality, the constitutional ethos behind the statute, the objective of the legislation, how do you prioritize the rights, which one will take preference over the other in the given situation. There is also, I must confess, I have deepest admiration and a sense of gratitude towards the district judiciary. My initial 6 months, I was practicing in district judiciary, and thereafter, next decade, also I practiced in the district judiciary. I found many of the judges at par with the judges in the High Court, and even sometimes better. It was sheer matter of luck that some got elevated to the High Court, but the respect I have for them and what I learned from many of the judges in the district judiciary was at par with the judges in the High Court. But one thing is very clear. In 1983, when I joined the bar, and my father was also in district judiciary, the service conditions as well as the state of infrastructure in the district judiciary was very, very poor. I have seen judges working in candlelight with handkerchief or a towel in their hands because to wipe off the sweat and also to ensure that the pen which they were using, the ink of the pen which they were using, does get blotted. There were no air conditioners. Forget about inverters or generators. The files used to be stacked from the floor, closing all the windows. There used to be hardly any sunlight. There used to be only 4 or 5 chairs on which we would sit and argue. But what has not changed since then, 1983 till today? It's been almost now 40 years. What has not changed is the admiration and respect which the judiciary commands, not only in the courtrooms, but from the public and the society. What is the reason for the same? Are we special? What is it that gives us that respect and reverence from the public? No, we are not special. We are not God's gift to mankind. What is special is the nature of work we do. By constitution, we have been conferred the right to sit in judgment over deeds and acts of fellow human beings. That's a very, very important task. If one looks at the legislature, it's a collective decision of the elected representatives. When we look at the executive, it is responsible to the legislature. The executive is also not a monolithic or an individual or 2 or 3 judges. So this shows the importance of our task because we have been equated as a third wing, or we are the third wing of the government, but very different from the other 2 wings. The responsibility on our shoulders put by the society is much more because it's an individual responsibility. That's the role all of you we are performing. We often overlook this fact when we decide cases. Why has the society given us that right? And the Constitution given us that right? In order to correct the wrongdoing, protect the innocent, and also punish the guilty. I distinctly remember as a youngster moving around playing with children, and somebody commented his father is a judge. He can send a person to prison. I didn't realize the importance of that statement, and I felt that statement was wrong. Later on, I felt it doesn't convey the truth, but it shows the importance of the power which we exercise, and therefore the caution we have to exercise when we exercise that power. The self-discipline, the self-imposed restriction, we have to keep in ourselves. Only then will the society, will the public have faith in us. Our wisdom, our acts our wisdom should be reflected in the acts which we do. I've also come across, and I must confess, we always carry hidden biases and prejudices. If you get an opportunity, please read a book called by the name of Thinking Fast and Slow by Daniel Kahneman. He is a Nobel laureate who died recently at the age of 90. And he used the words, we can be blind to the obvious. We are also blind to our blindness. Why do we carry prejudices and biases? Is because when we grow up during the years, we see certain things which we perceive are right and wrong. The education we get tells us this is right, this is wrong. Apart from this, we also sometimes, because of a class community we belong to, develop those biases in us about the others. As judges, we have to be cautious about that. In addition to it, there are certain more other biases which I felt. I've always checked myself during my term as a judge. We sometimes come to conclusions based upon limited evidence. Be careful of that. The sequence in which information is received also creates an element of bias. We also have what is called confirmation bias. We believe in some things, so the facts we look at will be accordingly, data and facts will get by that. Our individual biases, the way we have been brought up, impact our subsequent attitudes, and that's called the halo effect. How do I check that? How do I know I have a bias? One is to constantly remind oneself. The second thing is we must have in judging what I call cognitive flexibility. When I take up a case, when I take up a matter for hearing, I must be flexible. I should be able to go on both the sides. My views should not be so strong that I cannot take the other point, or I should not be able to take both the views into consideration. I've emphasized a lot on neutrality, but there is difference between neutrality and indifference. Neutrality certainly is one of the qualities of a judge, but neutrality is not indifference. There are situations when a judge must not act as a wall when justice demands that you choose the side of the oppressed. Archbishop Desmond Tutu had said, if you are neutral in situations of injustice, you choose the side of the oppressor. Having said this, now I'll turn to certain facts and figures with regard to Jammu and Kashmir, Ladakh, as well as all India figures. The first figure I've already given. The second figure is with regard to the pendency analysis in the district courts of Jammu and Kashmir. Almost 67% of the matters in the district courts are criminal matters. And total pendency is 3,14,539. We have the sanction strength of 296, working strength of 219 per judge. We have 1,436 cases per judge. The figure is not very big. It's not alarming figure, especially if we take it to, I don't have the breakup with regard to 138 and traffic challan cases. If we have that figure, probably we'll get the right situation, right, But there are two things I like to stop and, communicate my thoughts on. There has been over a period of time a general tendency to convert civil wrongs into criminal cases. And I have come across some cases from Jammu and Kashmir where I noticed this fact. Sometimes, as judges, we tend to accept criminal proceedings because they are faster, they resolve the matter faster, the wrongdoer is made to pay the money. That's not the right way. That's breaching the rule of law. You are actually damaging the institution. Our civil jurisdiction cases should be decided as expeditiously as fast. Ultimately, the damage caused is much more to the society. In long term, the consequences will be there. There are certain other aspects so you must know the difference between what is cheating, what is criminal misappropriation, what is civil wrong. These are certain principles which you must, whenever you go to criminal jurisdiction, judges, especially the youngsters, must keep in mind. I've got a set of judgments which I'll be passing on to your district court judiciary for the legal services, the academy, which will be then you can take help of. There are certain other basic principles because I saw the 67% is nearly the criminal jurisdiction, like section 34, the difference between unlawful assembly, common intention, the difference, how do we look at the case diary? The case diaries is something which is very important. And for the magistrates, it's my firm belief that whenever the accused is produced before you for the first time, you must inspect the case diary and sign them or ask your reader to put his marking. It'll reveal you a lot of things. Under the law, the police is the CRPC after the amendment, it's mandatory to maintain a bound case diary, which is page numbered. Each day the proceedings take place is to be recorded in the case diary. If you look at these things, it will help you to reach the right conclusion. As a judge of the High Court, I used to always call for the case diary. Obviously, I was dealing with most of the cases were murder cases where either there was appeal against conviction or appeal against acquittal. I'll always, and there have been cases where I have decided the matter after examining the case diary and completely overturned the judgment because I found the facts which were stated by the prosecution were not the facts which were revealed or came to the notice of the IO when he visited the spot. There were changes made, there was banding done, and it would help me to decide. This is the pendency in the district courts in Ladakh. It's just 151 cases. Here, the pendency is per judge. We have 9 working strength. I don't know whether we should go to 15 or not. It's for you to decide administratively. This is pendency in the Jammu Kashmir and Ladakh High Court. We have a working strength of 16 out of the sanctioned strength of 17. The total pendency is 45,209, out of which 8,445 are criminal cases. The criminal cases will constitute nearly, I think, about 18 point some percent. There's a drastic drop when it comes to the pendency in the high courts. There is, however, one sign of worry, and I must share that with you. That is that there are 1,651 criminal appeals which are pending. These is a very substantial sum, and the 5.95% of the total pendency is that of bail applications. That's again not a very good percentage. That has to be somehow we have to activate. 1,651 appeals is not a big number. It can be handled, but most of these appeals have to be taken up for hearing. I have also got some figures with regard to the criminal cases in the district courts, all pan-India. Your figures are some extent comparable, but better, and therefore you are ahead of pan-India. But nevertheless, I skipped that because I wanted to first point out you can do better. This figure gives out that 8,000 is about 18.7%, and the other details. Now I come to the under trials, which has been an issue which has been bothering everybody in India. Under trial population percentage is 75.76% of the total prison population, which was 5,73,220 as in end of 2022, 31st December 2022. The reason is very surprising. I did the breakup, and if you look at the breakup, I've given the breakup under 3 months, under between 3 to 6 months, and 6 to 12 months. 69% of the prisoners, that is about 3 lakh prisoners, are released within 1 year. So the judiciary, district judiciary is doing its job. It's the fresh intake we get. About 3 lakh plus people are put in prison every year. Now, how do we tackle that? We are doing our job because within 1 year, we are able to dispose of 3 lakh applications. That's a sizable number, given the fact that all India figure of district judiciary is about 25,000, which is a very small number. But how do we get to tackle this problem? We have to tackle this problem by ensuring the first day when the prisoner comes or the accused is produced before you, we see what exactly is the picture. It puts an additional burden on us, but it will help us in long term because it's not a very healthy side. Plus, we have to also ensure that if we can cut down the time from 6 months to 12 months, from 3 months to 6 months, within 3 months, the more you do it, the more the police will be then put into not arresting, knowing that he'll be put in for 1 year and then he can come out and the case will be then closed. No evidence will be produced, nothing will be happen. The accused gets punished without even the trial. So this is one thing we have to look into. Now, as far as under trial population in Jammu and Kashmir is concerned, it is slightly higher than Pan India figure. It goes to 86.3%. That's the cause of worry. But I've given the breakup. It shows that there's some delay in disposal of the applications because in first 2 years, first year we dispose of about 49%. Second year we dispose of about 18.25%. So we reached the figure of 67% in the first 2 years. So that has to be little, we have to little push that into the first year itself. And accordingly, then we'll be able to push between 2 to 3 years or between 1 to 2 years also. That's a task you'll have to take up yourself. All the district judiciary officers will have to take up that task themselves as an individual. And then our judicial academy can also come in and help. Ladakh is also the same figure, but I will not go by that. But the issue with the Ladakh, the problem really does not exist because there's under trial population is just 30. So that's a very small figure. So the figure here, I'm not too much bothered on that score. Now I've dealt with the issues. I want to now come to certain other aspects. How do we look at the future of the Indian judiciary? How do we move ahead from here? I'm not talking about knowledge, domain skills, that's something separate. I'm talking about the change in procedure, methodology we adopt. There are two things which are of extreme importance. Is multi-track case management approach. If you look at the Commercial Courts Act, now case management has been put into play. We had some time back British judges. They said when you file a case and you upload your case, the computer itself tells you the dates by which you have to file your written statement, replication, evidence dates are notified in advance for the plaintiff as well as defendant. And the tentative date when the judgment will be pronounced is also given. We don't have any such system. Probably we'll evolve and get hold of that system. If you can do it, be the first high court, first district court, you can do it. But we as individuals can do it. Depending upon the category of the case. Obviously, 138 case or case of traffic challan cannot be equated with the case of specific performance or partition suit. These are different. But you start working on this. The second is integration of technology into our judicial process. And that's happening in a very rapid way. One, obviously, is video recording. I think it's going to be the major game changer in the way we look at things. It helps us in recording the statement of witnesses, documentation, verification, timely court sittings, deterrence to unnecessary adjournments, reliability of the trial court records, facilitates transparency. I don't even mind in case for witness recording, we go ahead with audio recordings because that's very easy. It's comparatively very easy where video recording is not possible for technical reasons. We have started with transcription, and I think it's going to come up in a big way within the next 2-3 years. All constitutional bench matters while the arguments are being addressed, live transcription is being done from speech to text. It's almost live. And I've seen cases where I get about 100 pages of arguments by 6 o'clock in the evening. There's a center in Bangalore which also records and makes corrections. We have now floated a tender where live transcription will be done. Next is human resource management. This is of extreme importance. I think this exercise, and when I refer to the human resource management, I'm referring to several things, not one aspect. This slide gives us various mechanisms which we can adopt to have optimum judge ratio. Earlier, we used to follow the ratio of population. That has its flaws, several flaws. They have been 45th, 245th Commission report has gone to filing ratio, disposal method ratio, ideal case flow method, uh, and so on and so forth. None of these methods are foolproof. None of these methods are foolproof. As the next slide will show, that time taken in each case and case flow per judge has its drawback in the form that it incentivizes lower disposals. The former recommends increase in judges if the rate of disposal is low. There are inherent deficiencies of the system which can get covered by that. So we have to follow that. That's something which the Judicial Academy, the High Court must look into. The other thing is, how do we evaluate our performance, both as an institution and as an individual judge? This slide gives you various parameters which we should take into account while we evaluate judiciary as an institution as well as a judge individually. This is what I call, we normally follow what is called case clearance ratio method. This I'll skip out because this is more to deal with the Judicial Academy. But what it means is you take into account what is your intake, what is your outtake. If your outtake is more than your intake, the case clearance ratio is positive. You are not adding to the pendency. But if your output is less, then you are adding and contributing to pendency. Now, this is a very simple formula, but to work it out, sometimes it requires reliable data. Then it also requires comparable data. Each case has to be given some points, because a matter, say a complex matter being decided by you, cannot be equated by a simple matter. So it requires comparison, and do it yourself. Don't look at the Malimat committee report. Don't look at what the Judicial Academy for point purposes the High Court has said. Do it yourself. Self-evaluation is the best evaluation as far as individual justice is concerned. So that gives us reliable data, comparable data. Objective is to know how you're performing or how the institution is performing. I have gone beyond this, and I think only case clearance ratio is not the right method to understand the performance. I use the term key performance indicators. These are the aspects which, as an organization or an institution, as an individual judge, you must take into consideration. Here is the caseload per judge. That's normally case clearance ratio. On-time case proceedings is the second. Timely judgments is the third. Successful appeal rate is the fourth. Efficiency rate, that is the relationship between the number of personals used in the court in the year and the output of cases from the same court at the end of the year. Then cost per case. How much was the cost incurred to decide a case, whether it's going up or it's coming down? The cost incurred will be the cost as a unit. I'm not talking about the lawyer's cost. Don't forget about it. That's not a concern as an institution. And pre-trial custody in criminal matters. So there has to be, we have to evolve what is called pre-performance indicators, which will help us understand how well we are performing, which are the areas which require help. The last aspect which I want to touch upon is something which is very dear to district judiciary, is your annual confidential reports. I've added pluses and minuses. I'm not reading it. I think I've already overstepped my time, but this is one thing which has to be understood. I have one suggestion I want to put across. I'm putting it across. I don't know whether it will be implemented. It is acceptable to adopt a bell curve method in addition to ACRs. What is happening is we are grouping average with above average, excellent with above average. And that's most disheartening. So this bell curve approach helps us tackle that problem. In this approach, only 20% of your officers at the top will be graded as high performers. 10% at the bottom will be graded as below average performers. 70% will be graded as average or above average. Not that ACRs will be given up, but at least we'll be able to give credit to those who are helping the system, who are contributing to the system and doing much more than others. I don't know whether it's workable, it will be acceptable or not. It's just an idea. Think about it and let me know. I'm open to all sort of views on it, changing in percentages. Not that we're going to give up the ACR. We're going to continue with the ACRs, but why not give credit, due credit to those who overperform, who put in their heart and soul and do well. Lastly, this is a Goddard rule law and the Cobra effect. I dealt with the figures, but I know figures can be deceptive. Please do your own study. When a measure becomes target, it ceases to be a good measure. So be careful on that. Disposing of matters without doing justice will not be the answer. Thank you. Thank you for your kind attention.
Thank you, Lordship. We are deeply grateful for the profound edification of for sharing your Lordship's invaluable perception on pressing legal issues which will invigorate all judicial minds to strive for excellence, contributing to the holistic improvement of our legal system for the betterment of all. As we reflect on the words shared with us today in the presidential address, let us reaffirm our commitment to the ideals of justice and fairness. I now humbly request Honorable Mr. Justice Tashir Abastan, Judge, High Court of Jammu and Kashmir and Ladakh, to propose the vote of thanks.
Honorable Mr. Justice Sanjeev Khanna, Senior Most Judge, Supreme Court of India, and Executive Chairman, Nalsa, Honorable Mr. Justice N. Koteshwar Singh, Chief Justice, Jammu and Kashmir and Ladakh High Court, and Patron-in-Chief, Legal Services Authority, J&K and Ladakh. My esteemed brother, Atul Sridharan, Executive Chairman, Salsa Ladakh, Brother Sanjeev Kumar, Chairman, Judicial Academy, High Court of Jammu and Kashmir and Ladakh, esteemed sister and brother judges of the dais, judicial officers, LADCs, panel lawyers, PLVs, ladies and gentlemen. It is my great honor and privilege for me to propose the vote of thanks on this momentous occasion as my Lord Honorable Mr. Justice Sanjeev Khanna, Judge, Supreme Court of India, and Executive Chairman Nalsa is among us, despite vacation in Supreme Court, and has chosen to interact with honorable judges of the High Court and district judiciary of UT of Jammu and Kashmir and Ladakh instead of spending time at leisure. The vision of my lord and roadmap prepared for the judiciary will certainly take the judicial institutions in our country to the new heights. This is perhaps for the first time that Honorable Judge from Supreme Court of India has been pleased to have one-to-one interaction with the judges and other stakeholders involved in the justice delivery system with an aim to understand the issues concerning their functioning. Such kind of initiatives not only boosts the moral of judge, but also of those working in the system in enhancing their performance and also to overcome the shortcomings in the day-to-day working. This also helps in achieving the aims and object of proving quality and speedy justice to the public in general and litigants in particulars. I, on behalf of judicial fraternity of UT of J&K and Ladakh, assure my lord to work with the commitment and zeal towards realizing the goals set out by my lords. I also thank Honorable Justice N. Koteshwar Singh, our dynamic Chief Justice, with those initiatives. The idea of this interaction of my lord Justice Khanna with the judges and others could be made possible. The Honorable Chief Justice has always led from the front and taken keen interest in improving the working of legal aid institutions across the UT of J&K and Ladakh. It was only with the efforts of Honorable Chief Justice that the working days and honorarium of the PLVs was double during the previous year. I am equally grateful to brother and sister judges of the High Court who, despite their prior engagement and programs during the vacations, have joined us and graced this occasion physically as well as virtually. I acknowledge the keen participations of the officers of the High Court Registry, judicial officers from district judiciary, and the trainee judicial officers who attended the conference with zeal. I place on record my appreciation for the governing committee, J&K Judicial Academy, led by chairperson along with director and his team, for providing the venue and logistic support for holding this conference. The proactive and never say die approach of J&K Legal Services Authority needs special mention on this occasion, which has kept the flag of legal services fluttering high. Thank you very much.
Thank you, Lordship. As we come to the culmination of the program, I seek the kind permission of the chair to close the proceedings of the program. Thank you, Lordship. I request the participant to please stay for the photograph and thereafter proceed for the high tea. Thank you.